When filing a new trademark application at the United States Trademark Office, applicants have one of 5 choices: use in commerce basis, intent to use, foreign registration, a Madrid application, or a priority filing date based upon a foreign trademark application. When filing with an intent to use trademark basis, an applicant is claiming that they have a bona fide intent to use the mark in commerce. This has to be more than just the idea that, hey, this potential mark sounds good, I want to file it. When you file an intent to use trademark application, the biggest benefit is you get a constructive first use date based upon the filing date. So let's say you file an intent to use trademark application on July 1st of 2020. This mark proceeds to registration. What that means is any party that commences use of a confusingly similar mark after that July 1, 2020 date will be a junior user. And that means that if a party located in Wyoming starts using a confusing mark August 15th, even though they used the mark before you did, you are the senior user, you have trademark rights that you can enforce against that party because you filed with the United States Trademark Office prior to that date. Another advantage of an intent to use trademark application is that, let's say you want to use a mark in commerce, but you're not entirely sure whether or not it'll get approved or if another party will take exception to your use of the mark. If you file an intent to use trademark application and you do not commence use of the mark in commerce, it'd be very difficult for another party to really enforce a trademark infringement action against you because you haven't used it yet. And a disadvantage for filing an intent to use trademark application is the cost. When filing a trademark application, the cost is the same whether it's a use in commerce or an intent to use basis. However, if the mark is approved for publication with the use in commerce basis, the next step is directly to registration. On the other hand, with an intent to use filing basis, after publication, you'll receive what's called a notice of allowance. Upon receipt of the notice of allowance, you'll be provided 6-month periods of time to either file a statement of use or an extension of time. You're permitted up to 5 separate extensions of time. So what that means is if you file July 1, 2020, you could potentially obtain a trademark registration if you don't use the mark until 2023. However, each 6-month period of time, you will need to file an extension of time, which involves a currently $125 trademark office filing fee every 6 months. So the costs are higher for intent to use applications. However, if it's a very valuable mark for your company and you're worried about another party commencing use in commerce, it can often be very much worth your time and effort to file that intent to use application. If you have any questions, please feel free to reach out. We can be reached at 703-548-6284 or via email at ip@naflaw.com.